highlighted for in the order. If anyone is on and can't get video or audio, if you go to the town website and click on the boards and get the Board of Appeals, and then click on the right-hand box where the agenda is, the revised agenda tonight, you will find a link and a phone number to connect in here so you can get both visual and audio, hopefully. Okay, I'm going to have the members introduce themselves. I'm Dave Ryer, Chairman. Chris?
Chris Murphy.
Amy?
James Armstrong.
Ryan?
Brian Sullivan.
Al? Al, you're on mute, Al. You got to unmute.
That would be helpful. Alexander Donahue.
Okay, Al is our clerk, and Tim Bailey. Tim? Okay, you're on mute also. Welcome to Tim. Tim is an associate member. He's been appointed by the Board of Selectmen, so he is joining the board. Okay, I guess we can have our clerk, Al Donahue, call the first case, if you will, please, Al.
Case number 2020-55. Louis A. Burpee, through his attorney, William Kroll, has applied for a special permit, or in the alternative, a variance, to convert a pre-existing non-conforming garage into habitable space for a one-bedroom, single-family resident, attach an existing shed, construct a deck, and renovate an existing retaining wall. The application is pursuant to the Code of the Town of Harwich, 325-54, Table 2, area regulation as set forth in MGL Chapter 48, Section 6, and or Chapter 48, Section 10. The property is located at 9 Herring Run Road, map 36, parcel L11, in the RR zoning district.
Okay, thank you, Al. Attorney Kroll, I think, is representing this applicant, so if you would like to present your
Yes.
case.
Thank you, Mr. Chairman. Before I do, what I was referring to with the email to Shayla, just so you know, Mr. Chairman, is we're withdrawing the last petition tonight, withdrawing that without prejudice.
Okay, we'll have to make a motion to that effect, but you come with, when we come to it on the agenda, we'll handle it that way, if that's okay.
Thank you. So I'm Attorney William Kroll from Harwich Port, and I'm representing the petitioner Louisa Beaupre. Louisa, if you can press the video button so we can see you, that would be good.
Yep, I think I did. Can you see me?
Not yet. We can hear you. There you go.
Can you now? Okay.
We can see
Hi.
your room. Getting there. All right. So you work on that, and I'm representing Louisa this evening. The property in question is located off of Great Western Road on Herring Run Road in North Harwich. And we submitted a copy of the assessor's map and as well as the certified plot plan and the building and elevation plans for the dwelling to be constructed on the lot. We also submitted a copy of the denial letter by the building commissioner stating that we don't meet the side yard setback for the zoning district. And that's because the structure already exists and is 12.1 feet from the southeasterly lot line. As I understand it, and that was the building commissioner's only concern other than frontage, but when this subdivision was created back in 1966, the frontage requirement was only 75 feet. And that's why we have 75 feet of frontage. And it was back then 10,000 square feet of area. So I don't think frontage is an issue, but and back then the setback, sideline setback was 10 feet. So I think that's why the garage is closer than 20 feet, the existing structure. So my client purchased the property, this lot, a few years ago, and with the understanding that this was a buildable lot for single-family residents, and had a letter from a opinion letter from a local lawyer to that effect, that it is buildable for a single-family residence. And she purchased it, and she has a mortgage on the property that costs her $800 a month. And she has been to the Conservation Commission, and just recently had the order of conditions for this proposed dwelling approved again, a second time by the Conservation Commission. She's had the Board of Health approve the proposed septic system, and she has brought water, and the town and the electric company have brought water and electric into to the garage. So her contention is that this is a pre-existing non-conforming structure, that it's 12.1 feet and from the lot line, and she's seeking to intensify that situation, that condition, by adding habitable space to the garage, which we often do. I'm filing one tomorrow, same thing, where people are converting their garages to habitable space, and that's what she's seeking to do here. She would come with the deck that you see. The deck would be a little bit closer just due to the angle of the existing structure and the angle of the lot line. So it would come to 11.7 feet, just inches closer than the existing structure to the southeasterly boundary. So her contention is that this is a situation for a special permit, and that if the board saw fit to grant the special permit, there would be no substantial increase in traffic, noise, odors, fumes, congestion, or the like, and that the renovated structure would not constitute a substantial detriment to the entire neighborhood. And she would ask that you grant the special permit this evening. Thank you.
Okay, I really think it's a variance case, not a special permit, because what we have here is a garage. It's not either a single or two-family residential structure, which would, under the bylaw, be dealt with on the non-conforming basis as a special permit. And it's also not a residential accessory building, because it's not accessory to any existing residence on the lot. So I think you need to argue variance and convince us why a variance would be appropriate.
I can do that, Mr. Chairman. I respectfully disagree. There is that new case from the appeals court concerning the Gale case that considered a garage and said it's a special permit with a garage, which is a accessory structure to a residential dwelling. So they extended that to garages. And I think this board considered that a month ago with a case in Harwich Port. So with that new case, I don't think it's a variance case. I think it's a special permit case. I'll argue it both ways, but the ultimate point is that my client owns a lot which if it was vacant right now and it had never been built upon at all, it would be grandfathered under our grandfather clause for a single-family residence. If it already had a residence on it, she could renovate it with a special permit if the residence was too close to the lot line. She's got a unique situation in that there's a garage there. As I understand it, the garage was, the people that sold her the property owned the lot next door to the southeast. And that had a house on it. And then they had a garage on this lot. And then they decided to sell those two parcels separately because the garage was on this lot and not straddling the lot line or anything of that nature. And as I said, my client had got an opinion from a local lawyer who had met with our building commissioner at that time, 4 or 5 years ago, and said that based upon the conversation with the building commissioner and the review of the bylaw, that in his opinion, that was a buildable lot. In any event, ultimately what we're seeking is for her to have relief of some kind from this board because she already owns the property. She has a mortgage on it. She's got approval from the other departments, Board of Health, Conservation, et cetera, to have the single family residence. So in arguing the variance issue, which as you know, we have to argue that it's a unique shape, size, or topography to the lot or the structures on the lot. And there is a topography here with that's especially affects her lot because it drops off to the wetlands to the rear. It's a very large lot, uniquely shaped, but I think really the unique aspect of this property is the structure, and the statute says you can have a unique structure on the lot. The board could hang its hat on that there happens to be a garage on this lot that she wants to convert to a single family residence. And as I said, if the garage wasn't there, this lot would be grandfathered under our grandfather clause, and she could build because she has 75 feet of frontage and at least 10,000 square feet of area. Now, being a single woman with not, with all due respect, not a whole lot of wealth, it made sense to her to convert the garage as per the plans, attach that shed on the northerly side, and build a new deck and use the structure that's already there as opposed to building a new structure and having an attached single-family residence to the garage. She doesn't need the garage, doesn't want the garage, wants to use that structure so that she can have a single-family residence on the garage. So the hardship, due to the unique feature of this lot having a garage on it, is that she's already purchased the lot. She has a mortgage on the lot, and it would constitute a hardship to her to either move this garage, demolish and replace it, or build a residence attached to the garage that is more centrally located on the lot. So it's a financial hardship for her to, if the variance is not granted, she wouldn't be able to afford to create a single family residence on this lot. And as you know, we have many situations before this board where there's an existing single family residence where we come before the board for relief for a special permit under the Gale case to intensify an existing nonconformity. I think that this is still a Gale case because of that new case about the garage in, I think it was Swampscott. But if the board feels more comfortable granting a variance, then so be it. We just want relief so that she can build the single family residence. Thank you.
Could a residence be put on this lot? Forget the garage. If it were a vacant lot, could a residence be put on and meet the sideline and frontage line requirements?
I would suspect it could. She's trying to use what's there so that she can afford to build a single-family residence. But the lot is certainly big enough so that you could probably build a residence there if there were no garage. And she'd have to be 20 feet. So really, the only issue in my mind is she's 12 feet basically from the lot line as opposed to a new residence that would be 20 feet.
Okay, I have no further questions. Jamie, I'm going to go. I think I've got the case that you're referring to here.
I don't have any questions at this time.
Chris?
I just wanted to clarify. So the subdivision was created in 61 and these were separate lots in 61. They weren't split subsequent to that?
Correct. Correct. They were not split. These were existing lots in 1966. And in 66, the frontage requirement was 75 feet. And the lot next to it, to the southeast where the house is, that this couple owned both lots, they did not split the lots. They built a house on one, and at some point, we believe in 1971, an owner built a garage on the lot in question. But they were not split.
Okay. All right, and you referenced a case a month ago, and I mean, that doesn't matter, and obviously case to case, but that was not a habitable with a kitchen. It only had a bedroom.
Correct.
In that. It makes the
Correct.
difference obviously, with the dwelling versus accessory building.
As I said, this is a roundish peg into a squarish hole. Nothing is really black and white in this situation other than she owns it and needs relief from this board.
So to Dave's question, to ask it again, maybe a different way, if she were to demolish everything on this site and build the structure in the middle of this lot, and obviously there's a 100-foot setback, a lot of other things, would she be able to go in there and build that?
I'm not sure that she could. That's a very interesting legal question because the garage exists. And as I understand our bylaw, it has a unique kind of gray area that if the lot's vacant, you're grandfathered. If something got built on it, you may not be grandfathered anymore. You'd have to meet the current bylaw requirements of frontage, for example, 150 feet, as opposed to 75, and setbacks of 20 versus 10. If it was never, ever built on, as I understand our bylaw, she could be 10 feet from this southeasterly lot line.
I understand your gray area now.
She could demolish and replace and come 10 feet from the lot line as opposed to 11.7.
Okay. I don't have any other questions.
Brian?
Just want to clarify, was this land lot sold from the owners of 11 Herring Run, the Lightfords?
No,
All right, so they sold it to somebody else.
the Lightfords bought from the same owners that my client bought from, which was some people named Ashton.
All right, I'm actually a little confused, and maybe from reading the abutter's letter, I had the impression that the abutter sold 9 Herring Run, and then it went to perhaps somebody else who sold it to your client.
No, Lou Ashton and Pauline Ashton sold the abutter in 2015, and in 2017, the same sellers, Lou Ashton and Pauline Ashton, sold to my client for $130,000 for this lot. They both bought from the same couple. And I've seen the letter, and the suggestion that they split it because of the garage is I don't, that's not the case.
Okay, just wanted to.
Sure.
And Dave, you're saying that this doesn't come under the Gale case because this garage, they're looking not to put an accessory bedroom in there, but the difference between this and the case we had last month, where we granted a bedroom and a garage, but that did not have a kitchen. So is that the difference you're seeing here, where it doesn't qualify under the same reasons why we granted that under the Gale case last month?
Well, unfortunately, I can't put my hands at the moment on the actual case, but I have a little part, well, I have a footnote from it, and it really, the Comstock, it's Comstock versus Zoning Board of Appeals of Gloucester. And the footnote says the addition of a small storage shed is included on the list that the Supreme Judicial Court said is okay. Also included is the addition of a one-story, two-car garage without mention of whether such a garage was attached or freestanding. But that covers the addition of a garage, and what we're looking at here is converting a garage to a house. And I think the case that we had last session that Attorney Crowell is mentioning, to me, the law is not really clear on this point, and I agreed that we could handle it as a special permit. Really, I mean, it's whether it's really a special permit or variance case would have to be determined by a court in litigation. So if he would like a special permit, I think we could handle it that way. And if somebody wants to challenge it and, you know, find out otherwise through the courts, they're free to do that. I do not think it meets the requirements for variance.
I mean, my initial thing is because of the room, where it could be repositioned a lot and get you to 20 feet setback, it's very apparent. And having walked a lot, there's no reason why going north it could be repositioned, but then that's quite a hardship regarding the whole thing. And then I look at the fact that this building was built under a different set of codes, and now they want to remodel it into a single-family house.
Right. I don't think the hardship is met because the house can be located elsewhere on the lot and probably meet the setbacks. Financial, you know, the fact that it costs more money, I don't think under the stuff we looked at on the requirements for variance meets the requirement. That particular hardship is not due to the layout of the land, the topography. It costs more money. And I can't imagine the cost would be that great because it's going to be on the slab. It's not like there's a cellar hole there. Anyway, that's my feeling on it. Al, do you have any? I'm sorry, Brian, did you have anything further?
Not at the, are there any plans in the future to put another garage on the site, Attorney Crowell?
Not to my knowledge, no.
And obviously that shed is going to become, if I'm looking at the plans correctly, that's going to become the bathroom and a laundry room, correct? When it gets
Yes.
attached? Okay.
Yes. He's trying to
Now,
use is there.
Here's one question for you. If the building was moved north, is there still adequate land to put in the septic system?
Well, she'd have to go back to, I mean, it's a big lot. I can't answer that because of the wetlands issue. It's been a little tricky with the Conservation Commission. but moving it would involve the cost of moving the garage. It would involve redesigning the septic system in all likelihood, and going back to the Conservation Commission and changing the electric and water service possibly that has been brought in. So there is a significant expense to my client if the board wanted it moved. And as I say, we're only talking about basically 8 feet. To move it 8 feet, but that would be a significant expense, and at what, what's the gain? When you look at the cost benefit analysis, there's a lot of cost and not much benefit if she just moved it 8 feet. So I agree with the chairman that this is more of a special permit case. I think it meets the criteria for both, but I will defer to your judgment. We're just looking for relief from this board so that she can proceed.
Al, any comments, questions?
Yes, I do have a question. The neighbor at number 11 purchased that property in 15. And that property was subdivided by the individual that the plaintiff is referring to. Is there a deed restriction, if you know, on that property once it was subdivided?
Well, if I may, Mr. Chairman, it was not subdivided by the previous owner. It was part of a subdivision plan in 1966 that created both lots, my client's lot and the abutter's lot. That has not changed. Those have not changed. I've checked their deeds. They both each have, my client bought lot 11 on the plan and the abutter bought lot 10 on the plan. Nothing's changed. Nobody subdivided anything. That was subdivided in 1966. That has not changed. They bought the lots as shown on the plan and as shown on our certified plot plan. There's no splitting. There's no subdividing. There's no deed restrictions.
So the original owner of the land had a garage, which at some point, that land was separated so that the party on number 11, your client's property is divided, is separated from number 11.
She is number 11. She is number 11 on the subdivision plan. There was no splitting or separating. That the original owner of the entire area in 1966 had the Harwich Planning Board approve a subdivision plan that created these two lots. It's not changed since '66. Somebody, for some reason, built a garage on my client's lot and built a house on the adjoining lot.
So was that the lifers?
No, it may have been the Ashtons, but having not done a full title search to either lot, I asked my client, does she know when that garage was built? And she said, to the best of her knowledge, it was 1971. And the Ashtons, I don't think owned it back then. I can't say for sure because I haven't done a title search on it, on either lot, because that's not normally involved in this type of process. There is a title on the residence, on my client's lot that said the Ashtons acquired it in 1971, February 9, 1971. And it looks like they acquired the abutting lot somewhere around, I'm looking at the book and pages, are fairly equivalent. They may have acquired the house lot first maybe a year or so earlier and in 70, and then bought my client's lot in 71. And let me check one other source here. Says the assessor's information says that the Lyford house was built in 69. And that's right after the subdivision was created. And it looks like they acquired the Lyfords, the Ashtons acquired the lot next door, my client's lot, in 71. And then built a garage on it. That's what it appears to be. That's my educated guess from looking at the document.
I'm having a difficult time with regard to the Lyford. There is, I understand it, their home is at number 11. You represent the property owner at number 9.
Okay, we're crossing.
At some point, 9 and 11 were one piece of property.
No, sorry, Mr. Donahue, they weren't. They were separate lots and they were acquired as separate lots by separate deeds. They've not been merged. They didn't merge after 66 and then get separated again. They've just always been those separate lots. In the street number, you're right. The street number of Lyford is 11. The subdivision plan lot number is, for my client, is 11. That's what's confusing. So what you just stated about who owns which lot is correct, but these lots have never been joined.
All right.
Sometimes, I will say, sometimes what the assessor's office does, if you own adjoining properties, to save on administration of real estate tax bills, you'll see a little Z where they connect on the assessor's map, they connect the lots and say, okay, we're just going to send the Ashtons one tax bill because they own adjoining properties. I've run into this several times in the last several years where people come out with the wrong impression that somehow the assessors have the authority to merge lots, and they do not. They can merge them for taxation purposes to make it easier to send out tax bills and save, instead of sending 2 tax bills, they only have to send 1, but it does not legally merge those lots. And that may be where the confusion's coming from, is that people say, well, they bought them, they both own both of them, so they were merged. They weren't legally merged. And then when they sold them out separately, that they unmerged them and split them. Not true. It's always been 2 legal lots.
So that the piece of property that I'm going to designate as number 9.
Yeah.
That has been a lot that's been up for sale. Your client purchased that lot.
Correct.
That lot has contained this garage.
Yes.
That lot is sufficient by the looks of things, unless of course it runs across the issue with regard to the Herring River, could accommodate, based upon the frontage and the side layout, it could accommodate a home.
That's what we're trying to do.
But it could legally have a home on there, even if the garage was to be removed.
I'm not sure about that because of the reasons I already stated, that you may lose because they may have lost their grandfather protection because they built a garage on it. It's not a pure vacant lot anymore, and it doesn't meet the requirements of the grandfather clause.
Okay, I got no further questions.
Okay, Tim Bailey, any comments or questions? Tim? You got to unmute there. You're on mute. Tim?
I have no further questions. No questions. Can you hear me now?
Yeah, okay, thank you. Yep.
Okay.
Okay, is there anyone on the call in the public that would like to comment on this application? If so, please identify yourself and give us your comments.
Yes, Lyford, 11 Road. And what I can tell you that I have been told is that the lots were purchased together. The Ashtons, my house was built in '69. The Ashtons built the garage in 1987. There was electricity from my house to the garage, and there was up until a couple of years ago when I shut the fuse off. My understanding was if it is a merged lot or what's considered a merged lot, the tax bill was put together. And I actually had an issue with that when I first took over the property of getting the tax for both. They were unable to sell it too easily, so they were offered by their real estate. And my understanding was soon after, when people left, that they found out they were not going to be able to build, it was considered an accessory building. A number of people would actually come and look at the lot and come over to my house to ask, because it is so close, and ask where the line was, and that they were going to be heading to the building department, and I'd never see them again. So my concerns are that, yes, there's just about 12 feet or under from the front of the garage on the sideline. There's a little over 7 feet from the back of the garage to the property line. The building feels like it's going to be incredibly close to my line on both, even in the front of it where it's 12 feet, but in the back where it's just over 7 feet. So I do have a lot of concerns.
Okay, anything else, Ms. Lyford?
I guess I would want to have that clarified more about the merged property law, because it sounds like there's different interpretations of what's happening in that. And so I guess I would want clarification of that if possible going forward in this, but I just really needed to express those concerns and the facts as I know them. And,
Okay.
and the other thing too, I guess when it was divided in 2015, my understanding is that a home, if it was going to be divided, a home should have been put on at that point.
Okay, I'm going to ask Attorney Crowell to respond. I think you're on mute, Attorney Crowell.
Thank you. I knew if I pressed that button, I would regret it. So there's no time frame on or time deadline on building on in a subdivision where the road has already been put in, the utilities have been put in. So it didn't have to be built in 2015. And the characterization that's being made that when this was either split off or separated in 2015 when it was sold to my client, again, is not legally accurate. These lots have been the same lots since 1966. And that's how the deeds read. The assessor's office, with all due respect, confuses things by merging the tax bills. And Ms. Lyford just explained that she had trouble when she bought the house lot. The assessors kept sending her the bill that included this lot that my client now owns, because they had combined them into one tax bill. But the assessors don't have that authority to take away lot lines. These lots have never been merged, and they've been separate all along. You can ask town council, you can get a legal opinion, whatever you want, but I'm fully confident that I'm right in that regard, and that's where the confusion comes from.
Would you address her concern about the proximity to the lot line of the proposed house?
I would be repeating what I've said several times, which is that if this were a new house on a grandfathered lot, she would only have to meet the 10-foot setback requirement. So if we tore down the garage, demolished it, and said, okay, we now have if it's true that you would not lose your grandfather protection, then we could build a house that would be 10 feet from the lot line. There are a number of smaller lots, including Ms. Lightford's lot, but even smaller ones in that subdivision that I'm sure are just 10 feet from their lot line, neighbor to neighbor, so a total of 20 feet. So the Lightford house is, in all likelihood, no closer than 10 feet to their lot line, and this house would be 12.1, so that's a total of 22 feet, which is in many, many subdivisions that are grandfathered throughout our town. You have 20 feet from your neighbor's house. That's it. So this is not creating a large burden that doesn't exist elsewhere throughout the town. Trying to use the structures that are there with the budget that my client has to convert that to a single-family residence. And if you go with the special permit approach, as you know, the standard is very simple. Is this, if you grant the special permit and she can make this into a single-family residence, will that constitute a substantial burden or detriment? Will that create a substantial detriment to the entire neighborhood? And the law is clear, not just to the immediate abutter, Ms. Lightford, but to the entire neighborhood. Will this be a substantial devaluation of their properties? I would say clearly it would not be. It's not just a slight detriment. It has to be a substantial detriment to the entire neighborhood, not just the immediate abutter. And I respect the abutter's concerns, but that's the legal standard that you have to go by. And if challenged on appeal, that's the standard that the judge would go by in the Superior Court.
Okay, thank you, Attorney Kroll. Anything else from the public on this application?
If I could just add in that the utilities were actually not there prior to Attorney Crowell's client putting them in. They were there. The electricity was aligned from my house to there. So that is a difference, as well as the fact that the back of the house on the sideline is only over 7 feet, so it's not even the 12 feet. I also was told when I moved in that there wouldn't be a home there. If I knew that there was going to be a home that could be within 7 feet of my property line, I wouldn't have purchased it. So that there's a difference there. When the Ashtons were selling it themselves, they said that they were appealing to landscapers and construction companies that would use the garage. But of course, that was after I bought it. So if I had known that there was going to be a house that close, I certainly wouldn't have purchased it. I understand her position, and I am sorry for that position. I just want to make sure to protect my home and the neighborhood.
Mr. Chairman, I need to respond to that, please. I don't know where the 7 feet is coming from. Our plot plan that we submitted is 11.7, 11.7 for the deck, and the existing garage is 12.1. So it's not 7 feet. It's 12.1 from the lot line, number one. Number two, when the Ashtons sold the property, first of all, brokers and so forth will tell people whatever they want to hear. Oh, there can never be a house next door. You need to do your due diligence to make sure of that. They'll say, oh, you'll never have a house out there. That's conservation land. You have to be very careful of those things with all due respect to brokers. But also, when the Ashtons sold to my client, they gave her a letter from their lawyer, having met with our building commissioner, and the lawyer stated in the letter that this was a buildable lot. As a result of that conversation, put it in writing, my client relied on it, paid $130,000 for the lot. So, in my opinion, I think the board could see its way to granting a special permit in this situation. As I've explained, that would not be a substantial detriment to the entire neighborhood. And it's not 7 feet, it's 12.1 feet. Thank you.
Anybody else in the public would like to comment on this application? Hearing none, I'll entertain a motion to close the public hearing. Mr. Murphy, could I have a second, please? Mr. Sullivan, any discussion by the board? All in favor of closing the public hearing? Aye, 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 aye. Mr. Donahue, aye. Unanimous. Okay, public hearing is now closed. We'll have discussion by the board. As I've already stated, these two cases, the Comstock case, and they reference a Borland versus Zoning Board of Appeals of Norwell case. And I think what they've simply done here with respect to garages and other smaller structures on a property have confused the law. And it's not clear whether they can go forward with, at least to me, it's not, with a variance or a special permit. And I don't think it was clear to the Massachusetts appellate court either. But in any event, it's up to the applicant. It's their risk if they want a special permit and it turns out they need a variance. If it's not challenged during the appeal period, well, everything is good. If it's challenged, then they can argue the law. So I would be willing to vote for a special permit. I understand the concerns of Ms. Lyford, but if it's a special permit, Attorney Kroll, of course, has correctly stated the applicable law. It's whether or not the proposed structure, which would be the house in this case, is going to be substantially more detrimental to the neighborhood than the existing structure, the garage, and I think it's not. And he does correctly cite from the Ryder and Wilcox engineering stamped survey, the deck will be 11.7 feet from the lot line, and the house and the existing garage is 12.1 feet from the lot line. That's Ms. Lyford's lot line. I do think we need the construction time restriction and then our new general condition. There's no place to park there. I think it would have to be done off season. Pretty tight down there. Anyway, that's my 2 cents. Anyone else on the board have any comments, concerns, questions? Brian.
Yeah, David, I would agree with you. I drive the neighborhood looking. I'm looking. Thank God I took pictures. The adjacent house at 11, I don't think is less than 20 feet from the lot line. It looks like it's more like 12 feet or whatever. Other houses in the neighborhood also are close to lot lines. This is not an accessory building because it's on a separate lot. if it can be grandfathered in for 10 feet based upon when the lot was made, the existing structure is already there. I think it's something we can handle under a special permit.
Okay, thank you. Anybody else? No,
No, I'm in agreement with both of you with regard to the special permit. Given the location of the property and as described by council, many of these neighborhoods have only 10 feet on either side for a total of 20 feet between properties in most of these developments, at least the ones that were built in the late 60s.
and as you know, we see this throughout the town, especially down in the campground where houses are 1, 2, 3 feet from the lot line or from the front line. It's just the way things were done back then. All right, if there's nothing further, I'll entertain a motion in the case. Actually, I'll make the motion. I move that the board grant a special permit in case number 2020-55 to Louisa A. Brookford to convert a pre-existing non-conforming garage into habitable space for a one-bedroom, single-family residence. Attach an existing shed, construct a deck, and renovate an existing retaining wall. The application is pursuant to the Code of the Town of Harwich, Section 32554, and Table 2 Area Regulations as set forth in MGL Chapter 40A, Section 6, or the property is located at 9 Herring Run Road, map 36, parcel L11 in the RR zoning district. The board, having found that the proposed project will intensify one or more existing nonconformities, will not create any new nonconformity, will not be substantially more detrimental to the neighborhood than the existing structure. All work shall be performed in accordance with the plan submitted with the application. The special permit is granted subject to the following conditions. Number 1, there shall be no demolition, exterior construction, or new landscaping during the period from June 30 to Labor Day in any year. 2, it is in addition to this approval that a violation of the terms and conditions of the special permit may be enforced as a violation of the Harwich zoning bylaw pursuant to MGL Chapter 40A, Section 7, and the Harwich zoning bylaw, as these may be amended from time to time. Can I have a second on that motion, please? Jamie Armstrong. Any discussion on the motion? All in favor? Aye.
Aye.
Aye. The 5 regular members, I forgot to mention Attorney Kroll, the 5 regular members were voting. Mr. Bailey gets a free pass tonight. He will be invited to comment and ask questions, but we're not going to make him vote at his first meeting.
I
So the motion is carried. You have your special permit. I authorize in this case and in all our cases tonight for which relief is granted that our secretary, Shayla, stamp in all applicable documents. So you have your special permit.
Thank you very much, Mr. Chairman.
Thank you.
Thank you.
You're welcome. Good luck on the construction. Okay. Alice,
Thank you.
Next case, please.
All right, case number 2020-54, Jane C. Ibo.
Ayub.
Pronounce that.
Ayub.
Thank you. Owner of 23 Soundview Road and 27 LLC owner of 27 Soundview Road through their agent, Attorney William Crowe, have applied for a variance for said properties to allow for the equivalent and exchange of 750 feet of buildable upland between said owners pursuant to the proposed A&R, by Ryder and Wilcox, Inc., dated November 12, 2020, in the order to construct a garage. The applicant, in accordance with Mass General Law, Chapter 40A, Section 10, the property is located at 23 and 27 Soundview Road, map 26, parcel L1-10 and L1-9 in the RM zoning district.
Okay, thanks, Al.
Mr.
Attorney
Chairman?
Kroll, like to present
Yes.
your petition, please.
And I beg your indulgence tonight. I didn't plan on having this many petitions, but you folks joined up November and December into one, and then that was the beginning of January, and then that got pushed back, and then the agenda was too full, so here we are. And that's why I wanted you to know, Mr. Chairman, that we withdrew the last one without prejudice tonight. So I'm representing on this petition Paul and Jane Ayub, and you can see them on the screen now. As well, they own 23 Soundview, and we also have, I believe, the owner of 27 Soundview is either with us or on the screen or is listening in, but will be endorsing this petition, and obviously I'm representing that lot owner as well. So we submitted a copy of the assessor's map down near Red River Beach, kind of a little north of Red River Beach, almost to Red River itself. These lots abut that wetland and oversee Red River. And what we're seeking is variances for both lots. They are both pre-existing non-conforming lots, grandfathered, so to speak. And if they change their lot lines, then they lose their grandfather protection. So that's why we need variances for both lots so that they will not lose their pre-existing non-conforming status as to the occupancy of the single-family residence and the buildability of the vacant lot. 27 is a vacant lot. Now, why are we doing this? It's twofold, two reasons. One, so that the owners of 23 can build a garage as shown on the plot plan. And if you grant the variance to swap the equivalent amounts of square footage, the variances, then they can build a garage that will meet the setback requirements of 20 feet from their sidelines. That's number one. Number two, this all goes through the lot owners, both lot owners are approaching this from a minimalist approach, that all they want is a garage, a one-car garage on 23, and then 27 will donate the lot to the Harwich Conservation Trust. And I believe Michael Lark from the Harwich Conservation Trust will speak in a minute. But this is all part of a pre-planned arrangement. So that's what we're looking for, is to exchange 750 square feet between the two lots so that Mr. and Mrs. Ayub can build their one-car garage. Now, if you look at I'm assuming that you folks read the two-page petition request that I filed with the petition. And I don't want to belabor the points. We spelled them out as clearly as possible. But the existing dwelling at 23 has a garage in the rear of the dwelling. So you have to go around down towards the wetland, around behind the house to get into the garage. They don't want to run that risk of damaging the wetland resource area, and it's more or less impractical to get a car in and out of there at this point. So they thought it made a lot more sense to protect the environment, relocate the garage to the front of the lot, but not have it sitting in front of the house, between the house and the street. Would not be aesthetically pleasing. So it made sense to swap the land between the two lots. And our argument in terms of a variance would be that due to the unique topography of the lot, dropping off down to the wetlands and having a garage in the rear of the existing dwelling, that's a unique feature, an aspect of the lot that does not generally affect other lots in the same zoning district. And a garage is a reasonable accessory use for single-family residence. And there would be and they would experience a substantial hardship to not have a garage because it's a reasonable accessory use. And with all due respect to the Ayubs, they are admittedly getting a little bit older and want to have a garage to house their car. So there would be no substantial detriment to the public good if the variances were granted. It would not nullify or substantially derogate from the intent or purpose of the bylaw. And there would be no substantial increase in noise, odors, traffic, fumes, congestion, or the like. And it would not create a nuisance. And we would ask that you folks grant the variances for both lots this evening. Thank you.
Just looking at your plan, is it lot 9A that's going to be donated to the Harwich Conservation Trust?
9A plus 9B, the 700, I'm sorry, 9A plus 10B, which is the 750 feet that lot 9A gets from
Okay.
23.
Gotcha. Okay, I missed that. I thought it was all going to become 9B. Okay, 9A. Okay. And why do we need a variance to do this? Why can't you just do it by deed?
Well, you cannot subdivide by deed anymore in Massachusetts once we adopted the subdivision control law. We can't just carve out a parcel and say, okay, I'm going to deed that to you. You cannot subdivide by deed, number one. And number two, as I stated at the beginning, if you have a pre-existing non-conforming lot and you now change the lot lines, which we're proposing to do, then you lose your grandfather protection if you don't get a variance. So we're seeking relief from this board to make sure that 23's dwelling still it can be occupied legally, and that 27 would still be a buildable lot under our grandfather clause. But
Okay.
the upside of this is 27 is going to be donated. If these variances are granted, then 27 will be donated to the Harwich Conservation Trust and will remain vacant indefinitely.
Okay, thank you. And when was the garage last used, the present garage under the house?
I will ask Mr. Ayub to answer that.
Hi, good evening, everyone, and thank you for listening to this petition. I don't know. We've owned the house for
10 years.
10 years, and it wasn't used, and it doesn't, I don't think it's been used for a long time because the wetlands have grown in, and so it's now all grass and, you know, all grass and mud. So it's all wetlands now.
Okay, good, thank you. No, it looks like I was out there when was I out there yesterday or the day before, and it looks like it's pretty well grassed over and hasn't been used for some time. Thank you. I have nothing further. Jamie?
I don't have any questions.
Ryan? I'm sorry, wait, I skipped Chris. Chris?
Yeah, my only concern coming into this was that if this lot, if I guess 9A were to be built on in the future, that this makes it difficult, but if this is being given to the Harwich Conservation Trust donated, that's not an issue, and this is pretty straightforward, so I have no questions.
Okay, thank you. Brian? No, you got to unmute. Yep.
No questions. I'm all set.
Okay, Al?
I just want to start by apologizing for mispronouncing the last name, Ayu. Bear with me. I don't have any questions. I have spoken with the couple before, and I'm aware of the garage, which is not in the rear, which is unusable. So I have no further questions.
Thank you, Mr. Donahue.
Okay.
Donahue, I'm sorry.
Tim Bailey, do you have any comments, questions?
I have no questions.
Okay. Anyone in the public like to comment on this petition? Yes, Mr. Locke.
I'm Michael Locke, Executive Director of the Harwich Conservation Trust, the local nonprofit land trust that since 1988 has helped property owners preserve their lands throughout town. The AUBs reached out to HCT about 2 years ago to start exploring conservation options for their undeveloped parcel at 27 Soundview Road. They could sell the land for development or develop it themselves. And as you heard, in living next door at 23 Soundview, they've really grown to appreciate the area's natural qualities and wildlife and the stream habitat protection, since the parcel provides that upland buffer to the Red River estuary that flows to Nantucket Sound. They couldn't be more accommodating and working collaboratively to preserve this property at 27 Soundview through a planned donation of the land to HCT. So I support their approach and John's approach as well for the variance as described by Attorney Kroll. It makes sense and will ultimately help preserve an important natural area along the Red River estuary. So thank you for the opportunity to share support for the proposal.
Thank you. Anyone else in the public like to comment on this petition? Yes, ma'am. Yes, you have to unmute and then you can speak to us.
Hi. So thanks for taking a look at this. I'm John Leong. I'm the owner of 25 Troutbrook Road, which abuts 27 Soundview, and I'm a co-owner of the LLC of 27 Soundview. And we're very excited. Me and the AUBs are very excited to be able to preserve the land. That was our whole point in purchasing it, really, and keep it as open space. And we'd be really thrilled to be able to donate this to the Harwich Conservation Trust. And I think, the aesthetics of having a single car garage, small, off to the side, I think will be fine. I'm very much in favor of the petition.
Well, thank you for your generosity. It's a beautiful piece of land on a great location too, going down to the marsh and the river. So thank you on behalf of myself and the town. Anyone else in the public like to make a comment? I suppose in the interest of clarity, I should say that I'm a member of the Harwich Conservation Trust, but that's not going to affect my view of the case.
Mr. Chairman, if I may make a final comment? May I make a final comment, Mr. Chairman?
Yes, sir.
Attorney Kroll? Yes.
Okay, who was speaking? Okay, go ahead, Mr. Attorney Kroll.
Sure. I just wanted to point out that I've handled 2 or 3 of these types of land swaps in the past, where somebody discovers their house is too close to the neighbor, they not too close, but they encroach onto the neighbor's lot, and they need to carve out an equivalent amount. So I've done 2 or 3 of these before. It's not the first time that this board has granted or would grant variances to accommodate something like this. Thank you.
Okay. Anything further from anyone? Hearing no one, I'll move to close the public hearing. Could I have a second, please? Second, Mr. Murphy. Any discussion? All in favor of closing the public hearing? Aye, 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 aye.
Aye.
And aye, Brian. Okay, unanimous. Public hearing is now closed. Discussion by the board. I think this case does meet the requirements for a variance, given the topography out there. And I sometimes have questioned whether or not having a garage is a hardship, but certainly this winter has proven that you really do need a garage in this new climate that we have. And I think especially, you know, as we all are getting older, you really need to be able to get out there and not have to spend hours de-icing or shoveling out your vehicles. Let me just see one thing. So I do think that this case meets the requirements of section 10 of MGL Chapter 40A for a variance based on the topography of the property. And I would support the grant of a motion. Comments from the board members? Anyone? No comments? Okay, well. I guess we can do it as one variance motion citing both properties. Is that satisfactory to you, Attorney Kroll?
Yes.
Okay. Anybody want to make the motion? Okay.
I'll make the motion.
Go ahead.
Case number 2020-54. 23 Soundview, 27 Soundview LLC, owner of 27 Soundview Road, through their agent, William Kroll. The board hereby grants a variance, having found that the applicant meets the requirements of the bylaw in MGL Section 10, Chapter 40A, as stated with regard to the topography of the land. The variance is for the properties, it's dated, let's see, November 12, 2020, and the owner is pursuant to Ryder Wilcox. The application, in accordance with MGL Chapter 48, Section 10, the properties, I'm sort of repeating this, so I apologize. With regard to the demolition to the property, I don't know that that actually will be affected by what is being proposed. So I don't know that the...
I don't think we need any conditions because it's just a paper exchange, really.
Right.
There's no demolition.
No demolition.
No demolition. It is a condition on the, well, there are no conditions, so consequently, the board approves the variance.
If I may, Mr. Chairman, just make a comment, a suggestion on the motion, that you make it plural on and instead of a variance, variances, plural, so that it would be interpreted to be applying to each lot.
Okay, Mr. Donahue, is your motion so amended to for? the
Yes,
var-
I'll so amend my motion that it be a plural for variance.
Okay,
Variance.
I will second Mr.
Petitioner
Don.
will have to apply for a building permit for the garage. There's no demolition. He hasn't applied for the building permit. He has to get the variance first and then can apply for a building permit.
Right. Right. The only thing before us, Al, was just the land swap.
Right.
I'll second that motion. Any discussion of the motion by the board? Hearing none, I'll call for the vote. All in favor of granting these two variances? Aye.
Aye.
And
Aye.
Mr. You made the motion? Aye. So variances are granted. Thank you all.
Thank you.
Thank you all very much. We really appreciate your consideration. Thank you. Have a good night.
Well, it's a great thing, and I think you'll be happy with your garage, and it's a great thing you're doing the land swap.
Yeah, I'd just like to add my thanks.
Or the donation, I should say, not the swap, but the donation. Okay.
Thank you.
I guess case,
Case number 2020-1, David R.
no, wait a
Richard?
minute, back 2020-53, the applicant on this case, we don't need to call it, but the applicant on this case has requested a continuance to our next meeting is
March the 31st.
March 31st, 21. I see no reason not to grant them the request for continuance, so I'll move that case 2020-53 be moved to our meeting on March 31st, 2021. Could I have a second, please? Second, Mr. Sullivan. Any discussion by the board? All those in favor of the motion? Aye. Aye, unanimous.
Dave, you have to move to a particular time. Will you have that be 7 o'clock, the first case?
Have we had any filed already?
No, the deadline is tomorrow.
Okay, if there's none filed ahead of it, we'll make it the first case.
Oh, excuse me, I did have 3 come in already, so we can have it be the 4th case?
Yes. Yeah, they've already filed, so we'll make it the 4th case.
Okay.
Okay, Al, you can now call the next case, please, for us.
All right. Case number 2020-51, David R. Pritchett, through his agent, Attorney William Crowe, has applied for a special permit or in the alternative a variance to create a new habitable space in the basement of a pre-existing non-conforming single-family dwelling. The application is pursuant to the code of the town of Harwich, 32554, as set forth in MGL Chapter 40A, Section 6, or Chapter 40A, Section 10. The property is located on 24 Kroll Road, map 25, parcel N8-1 in an RM zoning district.
Okay, thank you. Attorney Crowell, if you could present your petition, please.
Yes. Thank you, Mr. Chairman. Attorney William Kroll from Harwich Port. I'm representing David Prickett and Bronwyn Monahan, his spouse, and Mr. Prickett is on the screen today. Hi, Dave.
Good evening.
As Mr. Donahue stated, this property is at the corner of Deep Hole Road and Crowell Road. We submitted a certified plot plan by Clark Engineering. The house exists. There will be no change to the footprint whatsoever. There will be no change to the parking arrangements for this property. They're seeking simply to finish off the basement, create habitable space, recreational space, but no bedrooms down in the basement, no kitchen down in the basement. All shown on the plot plan that was submitted, to have a recreation room, a bath, a coffee bar, and a sink in the basement. The building commissioner issued the so-called denial letter and said that on our west side is what it amounts to, I'm sorry, east side, we are 11.9 feet from the lot line, whereas the current bylaw calls for 20 feet. So the first floor has habitable space already, and so the basement under that first floor, we're seeking to create habitable space in the basement. So under the Gale case, we are intensifying an existing nonconformity. But we're not creating an apartment down cellar, and we're not creating a separate rental unit. We're not changing the parking or anything of that nature. It's just use by the Prickett and Monahan family to have a recreational area in the basement. So we're seeking to intensify that space. Under the Gale case, this board can do so with a special permit. The site coverage, by the way, is over the 35% limit. It's at 37.4, but the site coverage will not change because we're not changing the footprint. So we're not seeking to increase that at all, just the habitable space portion. And our argument would be that there would be no substantial increase in traffic, noise, congestion, fumes, odors, or the like, and there would be no substantial detriment to the entire neighborhood if the board saw fit to grant this special permit. Thank you.
Okay, I have no comments or questions. Jamie?
No questions.
Chris?
I have no questions.
Ryan?
My only question is, and I guess I need to understand the zoning laws better, but I don't know why we're here. We're remodeling a basement, and I'm not quite sure where it's not a bedroom. I thought this would be a building code and Board of Health issue, not a zoning issue. So I'd like to be educated as to why we're here, why a permit's required.
I
Besides
believe,
the fact the building inspector said so.
yeah, I believe, Attorney Crowell can correct me, it's because they're increasing habitable space within the setback, the 11 point, they're not meeting the setback, and they're adding to that nonconformity by increasing the habitable space in that area. Right, Attorney Crowell?
Yes, if we were building, Mr. Sullivan, if we were building the house today, we'd have to be 20 feet from the easterly lot line. We'd have to meet the current setback requirements. Since the house is already too close, on the first floor, it's grandfathered. On the basement, where you're increasing, you're creating habitable space, it's a new use within the 20-foot setback. So you have to have a special permit from this board to intensify the use in the basement.
I understand enhancing the basement. I understand why we're calling it habitable, but certainly they've been in the basement and using it. It has been habitable prior to this, whether you store it, whatever it might be, correct?
No,
That's why.
no, it's storage, not habitable. The key word habitable. If you're gonna put heat down there and electricity and so forth, baseboard heat, then you're making habitable space.
Thank you.
You're welcome.
Well, I got the education.
Okay, Al?
Just a comment to Mr. Prickett. Do you have grandchildren?
No, not yet. I've got 2 teenage boys. Don't rush me.
Yeah. The reason I brought it up is because have you ever given consideration to putting in an egress window for the basement? Because as I went around the property, it's the only opening you have is your bulkhead in the back. And since you're going to have, you know, people using a game room, I suspect, and a few other things down there, I just throw that out there. That's all.
If he did do that, Mr. Donahue, if he had, if it sloped off in the back and he could put a walkout slider or he could put an egress window, you'd have an egress window and stairs to the upstairs, which he does, then he could have a bedroom. Okay? he cannot have a bedroom without an egress window. And that would make it even more habitable, and you're exactly right. If you gotta worry about the kids sleeping down there, if there's a fire, they have to get out. So they have to have two means of egress, and one of them is an egress window.
Oh,
Thank you for the clarification.
Brian,
You're welcome.
yeah, I apologize. Is this house within the flood zone area down there near River Beach and so forth?
No, it's not.
Okay, it is not.
Correct.
Okay. So I thought you couldn't do a finished basement in the flood area. That's why I was asking.
Tim Bailey, do you have any comments, questions?
I have no questions.
Okay, thank you. Anybody in the public like to comment on this application? Anyone? All right, hearing no one, I'll move to close the public hearing. Can I have a second, please? Mr. Armstrong, any discussion by the board? All in favor of closing the public hearing? Aye. Aye. Unanimous. Public hearing is now closed. We'll have discussion by the board. I think this application clearly meets the requirements of the bylaw and the Gale case. It will intensify an existing nonconformity, but create no new nonconformities and will not be substantially more detrimental to the neighborhood than the existing structure. So I think it meets the requirements for this board to approve a special permit. Any comments by any board members? Hearing none. We should make a motion. Let's see. We do need, though, I think, the construction time restriction in our new general condition, because there's no parking in that area for construction vehicles during the summer. So I'll move that in case 2020-51, the board, let me try that again, board grant a special permit to David R. Prickett to create new habitable space in the basement of a pre-existing non-conforming single-family dwelling. The application is pursuant to the Code of the Town of Harwich, Section 325-54, is set forth at MGL Chapter 40A, Section 6. Property is located at 24 Crowell Road, Map 25, Parcel N8-1 in the RM zoning district. The board, having found that the applicant meets the requirements of the bylaw and the Gale case, as the proposed project will intensify one or more existing nonconformities, will not create any new nonconformity, and will not be substantially more detrimental to the neighborhood than the existing structure. All work shall be performed in accordance with the plan submitted with the application. This special permit is granted subject to the following conditions. 1, there shall be no demolition, exterior construction, or new landscaping during the period from June 30 to Labor Day in any year. 2, it is a condition of this approval that a violation of the terms and conditions of this special permit may be enforced as a violation of the Harwich zoning bylaw pursuant to MGL Chapter 48, Section 7. And the Harwich zoning bylaw, as these may be amended from time to time. Do I have a second on my motion? Chris Murphy, seconded. Okay, discussion by the board? Discussion, no discussion. All in favor of granting the motion? Aye.
Aye.
Aye, and Al Donahue, motion is granted unanimously. Thank you, Attorney Crowell.
Thank you.
Thank you for your consideration.
Hey, Al, you can call our next case, please.
Case number 2021-01. Russ and Ann Mcwaters, through their agent, Brian Wall of Cape Coastal Builders, Inc., have applied for a special permit to rebuild an existing bump-out addition at the rear of pre-existing non-conforming single-family dwelling and create two new additions along the same line as the existing structure. The application is pursuant to the code of the town of Harwich 32554 as set forth in NGL chapter 48, section 6. The property is located at 82 Pleasant Street, map 14, parcel M3 in the RM zoning district.
Okay, Mr. Wall, would you like to present your application, please?
Yes, thank you, Mr. Chairman. Good evening, Mr. Chairman and members of the board. For the record, my name is Brian Wall and I'm an attorney. I have an office in Sandwich, and tonight I'm representing the property owners, Russell and Ann Mcwaters, and also the contractor that will hopefully be doing the work, Cape Coastal Builders Incorporated. With me on the call tonight, the go-to meeting call, is Peter Barnard from Cape Coastal, and also John DeMarest from DeMarest Land Surveying, who prepared the plan. As the notice was read, the applicants are seeking a special permit to rebuild an existing bump out at the rear of the structure and to construct an addition in the same line as the existing structure. We've submitted an application, a site plan prepared by Mr. DeMarest, plans with elevations and the floor layout, as well as a written narrative. I know the board has probably read everything, so I'm going to be brief. I'm just going to track what I wrote in my letter. So by way of background, the property at issue is located at the corner of Bank Street and Pleasant Street. The address is 82 Pleasant. The lot is 19,659 square feet in area, and it is improved with a 3-bedroom dwelling. The property is located in the RM zoning district, and there are 2 existing nonconformities. The first is the lot size. The lot is 19,659 square feet. The minimum size required today is 40,000, so the lot's undersized. Secondly, the bump out at the rear is 14.2 feet from the rear property line, whereas 20 feet is currently required. I conducted some title research at the Registry of Deeds, and I determined that the lot was created at least as early as 1951. I think much earlier, but this lot was not subdivided under the subdivision control lot, so it's a little hard to determine exactly when it was created, but it predates 1951, and that's relevant for what I'm going to say in a second. Secondly, according to the assessing records, the dwelling was constructed in 1949. I think the board is aware that zoning was first adopted in Harwich in 1951. So both the size and the rear lot setback are grandfathered. They're basically pre-existing non-conforming. So Mr. and Mrs. Mcwaters, the project that they'd like to undertake is the following. They would like to make some improvements by remodeling their kitchen and their dining area, by adding a bathroom on the first floor, a farmer's porch, and a bulkhead for access to the basement. The farmer's porch is at the front of the house and is essentially seeking to cover an existing patio, and it is completely compliant with zoning. It's not actually even part of this application. Similarly, the bulkhead on the side of the property will be fully compliant with zoning. Currently, when built, it will be 33 feet setback, whereas the requirement is 20. The only aspects of the project that require relief are the bump out rebuild and the addition. So I want to talk about those for a minute. In the house now, the dining area is inside the existing bump out, which is a 14-foot by 18-foot structure that bumps out. I keep calling it the bump out. It bumps out from the structure at the rear towards the rear lot line. The Mcwaters seek to remodel this area, and Cape Coastal has determined that the most economic and efficient way to do this is to tear it down and rebuild it. Very important to know, the new bump out will be built on the existing foundation. The dimensions will be exactly the same as the bump out that's being torn down. There is no expansion of footprint, no increase in height, and no decrease in the setback. The setback will be exactly the same. The bathroom addition is on the first floor. It's proposed at the rear of the dwelling, off the hall that leads from the garage into the dwelling. It will be 9 feet 7 inches by 3 feet 6 inches. It will only be about 34 square feet. And if you review the plan, I'm going to try to articulate this. It's a little bit hampered with the video and not being able to point to a plan. But basically, there's the dwelling, and then on the left-hand side of the dwelling, there's a breezeway that connects the dwelling to the garage. The breezeway is thinner than either the house or the garage. So if you can kind of imagine in your mind's eye, it kind of looks like the letter I, so that the garage is bigger and the house is bigger, and the thinner part is the breezeway. The bathroom simply seeks to, the addition of the bathroom, we simply seek to take the existing rear wall of the house and run it across to the garage, filling in that kind of indentation on one side of the eye. The exterior wall will be set back further from the rear lot line than both the existing garage and the existing bump out, and it will in fact be 28 feet 2 inches from the rear lot line, and therefore compliant with current zoning. Thus, the proposed exterior modifications will conform to the current front yard and side yard setbacks and will maintain the existing rear yard setback. The building coverage will change very slightly, but will still conform to and remain well within current requirements. Currently, it's 8.9%. It will increase to 11.2. 20% is allowed. And the same is true for site coverage. It will increase very slightly, but it will remain within the current requirements. It will go from 24.1 to 24.4, whereas 30% is allowed. So as far as our contention and our argument, we cite to the Gale case, which I know the board is well familiar with. The Gale case tells us that we need to identify what respects the existing structure does not conform to the zoning bylaw, and then determine whether the proposal would intensify the existing nonconformities or result in new ones. If the answer to that question is no, the applicant is entitled to the special permit. And that's our contention. The nonconformities in this particular project are the lot area, which is obviously not changing, and the rear yard setback, which is also not changing. As I said earlier, the bump out is going to be in exactly the same place and will not change the existing 14.2 setback. The only reason it's part of the project is the definition of demolition, I believe, caused the building commissioner to say that relief was required. But we're basically taking down what exists and putting it back in the same place, in the same size, the same height. The bathroom addition will similarly not increase any nonconformity because it's set back much further than the existing 14.2 setback. It will simply square off an existing indentation, and it will not increase any nonconformity and complies fully with the existing bylaw. So I don't think I need to go any further, but if the board were to determine that one or the other of the proposed projects, aspects of the project, did in fact intensify one of the existing nonconformities, then we would argue the second prong of the Gale case and suggest to the board that these rather minor changes to this existing structure will not be substantially more detrimental to the neighborhood. There'll be no intensification of noise, traffic, congestion, odors, or the like, and certainly will not change the character of the neighborhood. That is the presentation. I'm available for questions. And again, I do have Mr. Barnard and Mr. DeMarest on the line in case there are any factual questions the board might have.
All right, thank you, Attorney Wall, for your presentation. I think I agree with you that this petition meets the bylaw and the requirements of the Gale case. Normally, as you heard from some of our prior cases, we would put a construction time restriction on, given the location. But I think here, and I want you to respond to this, we can simply require that all your construction vehicles park on site and not on Pleasant Street or Bank Street, because this property has the luxury of a really long, wide driveway.
Yes, it does.
I guess I'd like to hear from Mr. Bernard. Do you think you could live with that? Get all your vehicles on the site?
Yeah, there's plenty of room there, and we'd be happy to keep all of the vehicles in the driveway, the property itself. There's plenty of room.
Okay, and that gives your owner a little more flexibility on timing. We really impose that condition because during the summertime, a lot of our roads are pretty tight. So really try to accommodate the owners, but a lot of times it's not possible. You're fortunate your client has a nice, long, wide driveway.
Agreed.
Any comments or questions, Jamie?
Other comments?
Chris?
I have no question.
Ryan?
No, good presentation. I have no questions.
Al?
I have no questions.
Tim?
I have no questions.
One in like that would like to comment on this application? Hearing no one, I'll move to close the public hearing.
Hello?
What? Hello?
Oh, yes. Hi. Yeah, I just have one question. Sounds like a really nice project, and yeah, and sounds like it enhanced the property and not really changed too much. I guess the only question I had was there's a nice privacy border of arborvitaes. I was just wondering if those would be able to stay intact.
Wald, on that, or Barnard?
Yeah, Mr. Chairman, I have Mr. Barnard answer that question. But before I ask him, could I just have the caller identify himself for the record, just so we know who's talking?
Oh, yeah, sure. Sorry about that. Yeah, my name's Chris Yarswich, a budding property owner. Yeah, again, you know, welcome to the neighborhood. You know, like I said, wouldn't want to stand in anyone's way of improving their property. But like I said, we had a nice barrier between us and the previous owner, and you know, it just gave a nice element of privacy when you're in the backyard and when they were on their deck. And so, yeah, I just didn't know if those were able to be preserved or not.
We have been in discussions with Russell and Ann Mcwaters regarding the arborvitae. There's not been a final decision, but I am quite sure that the Mcwaters would want to preserve their privacy as well. I understand that that's obviously not a zoning issue, but whether or not they take them down, I'm sure that it would be replaced with a fence or something of the like. To, you know, they're interested in privacy as well.
If I could talk, Russell and Ann Mcwaters are on the call. I'm Russell Mcwaters, the new owner of 82 Pleasant Street. I appreciate the talk, Brian. It was very well done. As far as the privacy issue is, we understand your concerns. The arborvitaes do provide a lot of privacy, and if we were to do anything with them, we certainly would put up a high enough fence to at least ensure privacy for both of our yards, if that's the case. And I will reach out to you once I can meet you to discuss when that time comes.
Thank you.
Okay, yeah. I was just going to say, yeah, thank you. Yeah, very much. And yeah, like I said, if there's anything we can do too to help aid in that, I look forward to having a conversation about that, and hope everything works out. Good luck with your project.
Okay, thank you.
Thank you. Anyone else in the public want to comment on this case? Hearing no one, I'll move to close the public hearing. Can I have a second? Second from Mr. Armstrong. Any discussion by the board? All in favor of closing the public hearing? Aye, 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 aye. Unanimous. Public hearing is now closed. I think this case, as I stated, meets the requirements of both the bylaw and the Gale case. I think probably, I would argue it does intensify one of the pre-existing nonconformities, but it still meets the requirements of the Gale case. And I think the only conditions we need are that the vehicles during construction be parked on site and neither on Pleasant Street or Bank Street. and then our new general condition. Any discussion by the board? No. Hearing none, I'll make a motion that in case 2021-01, the board grant a special permit to Russ and Ann Mcwaters to rebuild an existing bump-out addition at the rear of a pre-existing non-conforming single-family dwelling and create two new additions along the same line as the existing structure. The application is pursuant to the code of the town of Harwich, section 32554, as set forth in MGL chapter 40A, section 6. The property is located at 82 Pleasant Street, map 14, parcel M3 in the RM zoning district. The board, having found that the applicant meets the requirements of the bylaw and the Gale case, as the proposed project will intensify one or more existing nonconformities, will not create any new nonconformity, and will not be substantially more detrimental to the neighborhood than the existing structure. All work shall be performed in accordance with the plan submitted with the application. Special permit is granted subject to the following conditions. 1, during the life of the project, all construction vehicles shall be parked on the property and not on either Pleasant Street or Bank Street. And number 2 is a condition its approval that a violation of the terms and conditions of the special permit may be enforced as a violation of the Harwich zoning bylaw pursuant to MGL chapter 40A, section 7, and the Harwich zoning bylaw, as these may be amended from time to time. Can I have a second on that motion, please?
I'll second that.
Seconded by Brian Sullivan. Any discussion by the board? In favor of granting the motion? Aye. Aye, 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 aye. Motion is unanimously approved. Your special permit is granted, Attorney Wall.
Thank you very much, Mr. Chairman, members of the board. Thank you. Have a good night.
Yep. This is Russell, and I want to thank the board also. I appreciate it.
Okay, Al, we can call our next case, please, if you will.
Case number 2021-02, Matthew E. Hubbard, through his agent Thomas Moore of Thomas Moore A. Moore Design Company, has applied for special permit to build an addition, add a porch and convert a garage into habitable space on a pre-existing non-conforming single-family dwelling. The application is pursuant to the Code of Town of Harwich 32554 and Table 2 area regulation is set forth in MGL Chapter 48, Section 6. The property is located at 10 Sunrise Lane, map 26, parcel B3-4 in the RM zoning district.
Okay, I guess, Mr. Moore, are you going to present your application, please?
Yes, I am. Good evening. Thank you. This is Thomas Moore from Thomas Moore Design Company representing Matthew Hubbard. We're requesting a special permit to add on and renovate the existing house at 10 Sunrise Lane. The existing house is non-conforming because of both of the sideline setbacks. On the left side of the property, it's 10.2 feet, and on the right side of the property is 10.5 feet. What we're doing to the house itself was there's a couple things where, one, we're adding a porch on the front of the house to kind of give it some curb appeal. That piece of the addition will meet setback requirements. The second piece is we're taking the existing garage and converting it to habitable space. We're creating a bedroom there. That's the part that is 10.2 feet from the property line on the left-hand side. And we have two additions that are going out the back of the house on the same lines of the existing house. They are both stepped in, so they do not get any closer to the side property lines. So we are intensifying a little bit of a setback or nonconformity in that respect. I believe that kind of falls in line with the town bylaws as far as adding on to a property in the same line as the existing nonconformity. these additions, this house is just a one-story ranch. We're just looking to create some more habitable space, family room in the back, expand the kitchen in one spot, and on the other is creating a new master bathroom. It's our contention that this proposal, will not create any nuisance, hazard, or congestion to the neighborhood, and that these additions onto this piece of property, which is actually almost an acre and a half piece of property. It's a very odd shaped piece of property, and the house was built in the narrowest part of it. So the lot coverage is really small as compared to what it could be. And we feel that these additions would not be substantially more detrimental to the neighborhood, and be happy to answer any questions.
Okay, thank you. Yeah, I think this case meets the requirements of the bylaw and the Gale case. I do think we would need the construction time restriction and then our new general condition on this property. That's all I have. Jamie?
I agree. No questions.
Ryan?
The only question I had was, I didn't see the site plan with a septic is. Not that it really matters.
It is right out behind the house. So, but it'll meet the requirements for setbacks from the septic system.
Okay, thank you. I'm all set.
Okay, Al?
I have no questions.
Chris?
I have no questions.
Tim?
I have no questions.
Okay, is there anyone in the public that would like to comment on this application? Hearing no one, I'll move to close the public hearing. Can I have a second on that motion, please? Okay, Jamie Armstrong, second. Any discussion by the board? All in favor of closing the public hearing? Aye, 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 aye. Public hearing is closed. The vote was unanimous. Any discussion by the board on this particular case? No? I'll entertain a motion on the case from somebody, please.
Make the motion on case number 2021-02. The board, excuse me, the case of Matthew E. Hubbard through his agent, Thomas Moore. The board hereby grants a special permit, having found that the applicant meets the requirements of the bylaw and the Gale case. And that the property proposed project will not intensify or create a new non-conformity and will not substantially nor detrimental to the neighborhood than the existing structure. All work will be performed with the plan submitted with the application. The special permit is granted subject to the following conditions. The property is in a congested area. There shall be no demolition, exterior construction, or new landscaping during the period of June 30 to Labor Day in any year. During the life of the project, all construction vehicles shall be parked. In this case here, I don't think they can be parked on the property.
No, we just need the number 3 there.
Yeah, it is a condition of this approval that the violation of the terms and conditions of the special permit and may be enforced as a violation of the Harwich zoning law bylaw pursuant to General Law, Chapter 48, Section 7, and the Harwich zoning bylaw as these may be amended from time to time.
Okay, just one clarification. I think you said the project will not intensify one or more existing nonconformity. It actually will intensify. I think you just misspoke there.
Okay.
It is intensify one or more existing nonconformity, but it still meets the requirements of the bylaw in the Gale case. I'll second that motion. Any discussion on Al's motion? All in favor? Aye.
Aye.
Aye. Motion approved unanimously. Mr. Moore, the special permit has been granted to your client.
Thank you very much. Have a good evening.
Okay. Al, you could.
All right, case number 2021-03. Michael J. Kelly and Brenda M. O'Malley, through their agent, attorney William Kroll, have applied for special permit or in the alternative a variance to demolish and replace a pre-existing non-conforming single-family dwelling. The application is pursuant to the Code of Town of Harwich 32554, Table 2, Area Regulation as set forth in MGL Chapter 48, Section 6, or 48, Section 10. The property is located at 10 Jason Lane, map 23, parcel P8-2 in RL zoning district.
Thank you. Attorney Kroll, would you like to present your petition, please?
Yes, Mr. Chairman, thank you. Attorney William Kroll from Harwichport. I'm representing Michael Kelly and Brenda O'Malley, who are on your screen, couple that own the property. This property is located off of Bank Street on Jason Lane, and I submitted a copy of the assessor's map. If you'll indulge me for just a moment, you mentioned a few months ago that some of you had read the article that I wrote about playing for the Harwich Mariners way back when. In 1970, when I first played, 5 of my teammates stayed in this cottage before it was renovated, and they called it the Palace. The coach was the building inspector for the town, and he had condemned this cottage, and he uncondemned it so that the guys would have a place to stay. And I went to a party there one night, and my foot went through the floorboards, so it was in need of repair. And it was owned by Audrey Speakman, and her son Jay and I were best buddies growing up, and Jay's son is Jason, and so that's why it's called Jason Lane. So I have to add a little local history when I can.
Well, thank you. It's been a while, so we appreciate that.
All right. So in any event, it was renovated prior to this, upgraded from the Palace to whatever it was when the Kelly and Brenda O'Malley bought it. We've submitted the building and elevation plans. As you can see, the existing dwelling shown on the Moran plan is only 2.3 feet from the edge of the traveled way known as Jason Lane. And the new dwelling will be 6.5 feet from the edge of Jason Lane. So in the denial letter, the building inspector said that we don't meet the required front yard setback. So we're supposed to be under the building, under the bylaw, we're supposed to be 25 feet from the edge of Jason Lane. We're pre-existing non-conforming, Mr. Sullivan. So we don't meet the 25-foot setback for having habitable space. But in fact, we're making it better, even though we're intensifying it by creating more habitable space within the 25 feet. We're decreasing the non-conformity, making it more conforming by stepping it back from 2.3 to 6.5 feet. So it's another Gale case situation, and this new dwelling, it's our contention, would not constitute a substantial increase in traffic, noise, odors, fumes, congestion, or the like, would not create a nuisance, and would not be a substantial detriment to the entire neighborhood. And we'd ask that you grant the special permit this evening. Thank you.
Okay, yes, I agree. It meets the bylaw in the Gale case. What is Jason Lane? is it a private road or?
Yes, yes. The main house out by Bank Street, this was all owned by Audrey Speakman. And the main house and she rented the cottages in the back. So there's 2 or 3 cottages behind the main house, and the access road was this dirt road. And when they renovated it, and I believe when one of the prior owners bought the main house and the cottages all at once, they created this subdivision plan to show that they were each on their own lot and their access and frontage was off of Jason Lane.
Do the individual lot owners have easements in it, or just an implied right to use it?
I represented the prior owner that created this subdivision. I believe that we, as they sold out each lot, that we reserved a right of way over that road, so that there are easements of record, is my recollection. It was about 20 years ago.
Okay, that's fine. I have nothing further. Jamie?
No, I have no questions.
Chris?
Yeah, I have one question on the plan. It looks like on the second floor, is that a door with no stairway?
Mike or Brenda, can you answer that question?
There's a stairway. To go up to the second floor? Yes, there's a stairway.
It doesn't show on the plan or on the elevation.
It should be right in front of the back door, just parallel to the back door.
Yeah, going up.
So right at the end of the living
The
room.
one that goes up to the future room.
Correct,
Yes.
yeah, right at the very end of the living room, in front of the door that goes to what we call the backyard.
Which is the south lot line.
It doesn't show on the elevation. There's a window below it, and it just shows a door. And that was, it looks like a door with no stairs on the elevation. So
Okay.
I have no other questions. If it's that's not a zoning issue anyhow. It's a building.
Brian?
I'm all set, thank you.
Al?
I have no questions.
Tim? Tim, any questions?
I have no questions.
Okay. Is there anyone in the public that would like to comment on this application? No one. I'll move to close the public hearing. Could I have a second on that motion, please? Second, Chris Murphy. All in favor? Aye.
Aye.
Aye, aye. Okay. Unanimous. Public hearing is now closed. I'll move case 2021-03 that the board grant a special permit to Michael J. Kelly and Brent M. O'Malley to demolish and replace a pre-existing non-conforming single-family dwelling. The application is pursuant to the code of the town of Harwich, section 32554 and table 2 area regulations. Is set forth in MGL chapter 40A, section 6. Property is located at 10 Jason Lane, map 23, parcel P8-2 in the RL zoning district. The board, having found that the applicant meets the requirements of the bylaw in the Gale case, as the proposed project will intensify one or more existing nonconformities, will not create any new nonconformity, and will not be substantially more detrimental to the neighborhood than the existing structure. All work shall be performed in accordance with the plan submitted with this application. This special permit is granted subject to the following conditions. 1, there shall be no demolition, exterior construction, or new landscaping during the period from June 30 to Labor Day in any year. 2, it is a condition of this approval that a violation of the terms and conditions of the special permit may be enforced as a violation of the Harwich zoning bylaw pursuant to MGL chapter 40A section 7 and the Harwich zoning bylaw as these may be amended from time to time. Can I have a second on my motion, please? Okay, Brian Sullivan, second on the motion. Any discussion by the board? All in favor? Aye?
Aye.
Aye. Motion is unanimously approved by the board. Your special permit is granted, Ms. Kelly, Mr. Kelly and Ms. O'Malley.
Thank you very much.
Names are opposite where you are, and
Have a nice evening.
Have a good
Thank
night.
you.
Thank you.
it's getting later for us old guys, so I'm much more easily confused than even normal.
Thanks for your work.
All right.
Have a good night. Thank you.
Okay, thank you. Good luck on your project. Okay, Al, we call the last case.
Case number 2021-04. Robert F. Standelick and Patricia A. Standelick. How they do on that, Mr. Kroll?
Stadalnik. Stadalnik.
Thank you. Through their agent, Attorney William Kroll, have applied for a special permit or in the alternative, a variance to remove and add a second floor in the same footprint pre-existing non-conforming single-family dwelling. The application is pursuant to the code of the town of Harwich 32554, Table 2. Area regulation is set forth in MGL Chapter 40A, Section 6 and or Chapter 48, Section 10. The property is located at 298 Lower County Road, Map 12, Parcel W2-5 and RH-1 zoning district.
Okay, Attorney Crowell, you indicated you wish to withdraw without prejudice.
Yes, Mr. Chairman.
Okay, you don't want to continue, you just want to withdraw.
Correct.
Okay, I will move that the board grant a motion to continue in case 2021-04, Robert E. Stadolnik and Patricia A. Stadolnik. Can I have a second on that?
Was that without prejudice, Mr. Chairman? Was that without prejudice?
Without prejudice, yes.
Yes, thank you.
Second by Mr. Armstrong. Any discussion by the board? No? All in favor? Aye. Aye. Motion unanimously. Okay. So that case is withdrawn.
Thank
All right,
you.
thank you, Attorney Kroll. Have a good evening.
Thank you. I did. Thank you. And you enjoy it also.
Oh, you're not leaving?
I am leaving. As soon as I can
okay.
figure out how to leave.
And thank you for the little history, the town history.
You're welcome. Here we go. Let's see.
Okay, so now where's my note? Okay. You saw, I sent it around. We have in case 2020-01, a request to grant an extension to the variance which the board previously granted. Where is it? The board granted a variance on January 29, 2020. The applicant has asked that we grant an extension of the variance to October 28, 2021. The request was received before the existing variance expired, although there are decisions all over the lot as to when the initial variance became effective. But I think the better reasoned decisions are that the variance is not really effective until all of the appeal time periods have run. So in that case, the applicant's request was timely, and I'll move that we grant an extension of this variance in case 2020-01 to October 28, 2021. Can I have a second on that motion?
Second.
Second, Chris Murphy. Any discussion by the board? All in favor of granting the extension?
Aye.
Everybody in favor, unanimous, so the extension is granted. On the minutes of our January 27th, 2021 meeting, I did request on the conditions, condition number 2, Shayla, I think 3 or 4 words were dropped out, so Shayla reinserted them. That's the only change I had. Did anyone else have any changes to those minutes?
No.
Okay, I'll move that we approve the minutes of our January 27th, 2021 meeting as amended by these couple of minor administrative changes. Could I have a second on that motion?
Second.
Second from Al Donahue. Any discussion? All in favor?
Aye.
Minutes approved unanimously. I think that's all I had. Anyone have anything?
I just wanted to mention that I will be going in for some surgery at the end of the, well, it's springtime. And I will have somebody that will back me up for probably the May and possibly the June meetings.
Okay, well, what's the word? Early good luck wishes on it. So
Thank you.
when is it going to be? In May, your actual surgery?
No, yeah, my actual surgery will be in May and towards the end of May. So I'll pretty much have everything in place, I think, for the May meeting, but I just won't be able to be at it or on the tube. And then I'm not the June, it's about my back. So I'm having a lot of trouble sitting. So we'll see where I am by the end of June and what I can do from there.
Okay. Do you want us to try to chip in? We'll get a sumo wrestler to come over and walk on it, like, you know, and then snap the backbone and get it back, sort of like the chiropractors do.
Oh, I think I need a lot more than that.
Yeah, well, good luck with it. Backs are no fun. Yeah, unfortunately.
So I will keep you up to date as to who will be backing me up on that, so to speak.
Okay. Well, thank you for alerting us, but we will miss you and wish you luck.
Thank you.
Anybody else? Any comments?
Oh, and we, like I said, we have 3 cases already in for the March hearing. I think that there are at least 3 more coming, and then the one that was continued. So it looks like another heavy night.
Boy, yeah. Well, you know, it's too early now, but we might want to think as we get into the fall about maybe putting on an extra meeting to make up for the one we're consolidating.
Well, I don't think we need to this December. It was that last year and this year, the holiday fell either the night before, the night of, or the night after either Thanksgiving or Christmas. I think we have a bit of a leeway this year. I think it moves away from the actual day. So I think we can have two meetings, one in November and one in December. I think we have it on the schedule as then.
Yeah, you do. It's on schedule.
I figure it's too early to think about it, but I figured when we get to the fall, we'll take a look and see what we think. Because it seems like we're sort of trying to still work off the backlog, and here we are going into March already, the next meeting.
Well, it's just also an incredibly busy build time. So we are inundated with applications. And I just think through COVID, people are looking around and thinking, well, we're not going on a vacation. What should we do to the house?
Yeah.
There's a lot of that.
You hit a nail on the head right there.
Yeah.
All right, if no one has anything else, I'll move that we adjourn our meeting. Can I have a second, please? Jamie Armstrong, all in favor? Aye.
Aye.
All right, thank you all. Have a great one. Good luck on your second shots. And we'll see you whenever, what did I say, March 31st, I guess.
March 31st.
Yep.
All right.